The Federal Court of Australia is now in session. Please be seated.
In the matters NSD 1485 of 2018, Ben Robert Smith and Fairfax Media Publications Proprietary Limited and others, NSD 1486 of 2018, Ben Robert Smith and the Age Company Proprietary Limited and others, and NSD 1487 of 2018, Ben Robert Smith and the Federal Capital Press of Australia Proprietary Limited and others, for judgment.
Yes, in accordance with the practice of the Federal Court in cases of public interest, the following summary has been prepared to accompany the orders made today. This summary is intended to assist in understanding the outcome of this proceeding and is not a complete statement of the conclusions reached by the Court. The only authoritative statement of the Court's reasons is that contained in the published reasons for judgment, which will be made available on the internet at the Court's website. This summary will also be available there. Mr. Ben Robert Smith VC MG has brought 3 actions in this court for defamation. The first action is brought against Fairfax Media Publications Proprietary Limited, Mr. Nick McKenzie, Mr. Chris Masters and Mr. David Rowe. The second action is brought against the Age Company Proprietary Limited, Mr. Nick McKenzie, Mr. Chris Masters and Mr. David Rowe. The third action is brought against the Federal Capital Press of Australia Proprietary Limited, Mr. Nick Masters, and Mr. Nick McKenzie, Mr. Chris Masters and Mr. David Rowe. The 3 proceedings have been heard together. There are a total of 16 matters complained of. The publications appeared in newspapers and were made available online. The articles may be divided into 3 groups. The first group of articles were published on the 9th and 8th of June 2018. The applicants claimed that the following imputations were conveyed or communicated by the Group 1 articles. 1. The applicant, while a member of the SASR, murdered an unarmed and defenceless Afghan civilian by kicking him off a cliff and procuring the soldiers under his command to shoot him. Imputation 1. 2. The applicant broke the moral and legal rules of military engagement and is therefore a criminal. Imputation 2. 3. The applicant disgraced his country Australia and the Australian Army by his conduct as a member of the SASR in Afghanistan. Imputation 3. The second group of articles were published on the 10th and 9th of June 2018. The applicant claimed that the following imputations were conveyed or communicated by the Group 2 articles. 1. The applicant, while a member of the SASR, committed murder by pressuring a newly deployed and inexperienced SASR soldier to execute an elderly unarmed Afghan in order to blood the rookie. Imputation 4. 2. The applicant, while a member of the SASR, committed murder by machine gunning a man with a prosthetic leg. Imputation 5. 3. The applicant, while a member of the SASR, murdered an unarmed and defenceless Afghan civilian by kicking him off a cliff and procuring the soldiers under his command to shoot him. Imputation 1. 4. The applicant, having committed murder by machine gunning a man in Afghanistan with a prosthetic leg, is so callous and inhumane that he took the prosthetic leg back to Australia and encouraged his soldiers to use it as a novelty beer-drinking vessel. Imputation 6. The applicant was not named in the Group 1 articles or the Group 2 articles. A soldier called Leonidas was referred to. By the end of the trial, there was no dispute about the identification of the applicant in the Group 1 and Group 2 articles. The third group of articles were published on the 11th and 10th of August 2018. The applicant was named in these articles and there was never any identification issue. The applicant claimed that the following imputations were conveyed or communicated by the Group 3 articles. 1, the applicant committed an act of domestic violence against a woman in the hotel realm in Canberra, imputation 7. 2, the applicant is a hypocrite who publicly supported Rosie Batty, a domestic violence campaigner, when in private he abused a woman, imputation 8. 3, the applicant, as Deputy Commander of a 2009 SASR patrol, authorised the execution of an unarmed Afghan by a junior trooper in his patrol, imputation 9. 4, the applicant, during the course of his 2010 deployment to Afghanistan, bashed an unarmed Afghan in the face with his fists and in the stomach with his knee, and in so doing alarmed 2 patrol commanders to the extent that they ordered him to back off, imputation 10. 5, the applicant, as patrol commander in 2012, authorised the assault of an unarmed Afghan who was being held in custody and posed no threat, imputation 11. 6, the applicant engaged in a campaign of bullying against a small and quiet soldier called Trooper M, which included threats of violence, imputation 12. 7, the applicant threatened to report Trooper J to the International Criminal Court for firing at civilians unless he provided an account of a friendly fire incident that was consistent with the applicant's, imputation 13. 8, the applicant assaulted an unarmed Afghan in 2012, imputation 14. The first issue in the proceedings is whether the imputations alleged by the applicant were conveyed or communicated by the articles. There was no dispute between the parties that the Group 1 articles conveyed or communicated imputations 1, 2 and 3. There was no dispute between the parties that the Group 2 articles conveyed or communicated imputation 1. There was a dispute between the parties as to whether the Group 2 articles conveyed or communicated imputations 4, 5 and 6. I find that those imputations were conveyed by the Group 2 articles. There was also a dispute between the parties as to whether the Group 3 articles conveyed or communicated any of imputations 7 to 14 inclusive. Subject to one matter concerning imputation 9, I find that each of those imputations are conveyed or communicated by the Group 3 articles. The one qualification is that in the case of imputation 9, I find that the imputation which was conveyed or communicated was as follows. The applicant, as Deputy Commander of a 2009 SASR patrol, acquiesced in the execution of an unarmed Afghan by a junior trooper in his patrol. The defences of the respondents in each proceeding are similar. They are justification or substantial truth, section 25 of the Defamation Act 2005, New South Wales, and contextual truth, section 26 of the Defamation Act. With respect to the defence of justification or substantial truth, the respondents' particulars of truth are very substantial. They consist of in the order of 150 paragraphs. With respect to the defence of contextual truth, The respondents in each action plead that imputations 2 and 3, as pleaded by the applicant in relation to the Group 1 articles, arise as contextual imputations in the case of the Group 2 and Group 3 articles, and that they are substantially true. If that is so, they have a defence where the defamatory imputations pleaded by the applicant, to the extent that they are not shown to be substantially true, do not further harm the reputation of the applicant because of the substantial truth of the contextual imputations. In the alternative to these two defences, the respondents plead a number of matters which they contend mitigate damages. The most serious allegations made in the particulars of truth are that the applicant murdered or was complicit in and responsible for the murder of Afghan males who were under control or containment. That allegation is made in relation to 2 Afghan males on a mission to Whiskey 108 on the 12th of April 2009, 1 Afghan male on a mission to Darwin on the 11th of September 2012, 1 Afghan male on a mission to Chinatu on the 12th of October 2012, 1 Afghan male on a mission to Sire Chow on the 20th of October 2012, and 1 Afghan male on a mission to Faisal on the 5th of November 2012. The particulars of truth also contain a serious allegation that the applicant assaulted person 17 on or about the 28th of March 2018 in a hotel room in Canberra. In addition, there are allegations against the applicant of assault of Afghan males under detention, bullying of an Australian soldier, and making a threat to another Australian soldier. The trial was interrupted because of the effects of the COVID-19 pandemic, and thereafter occupied a substantial period of time. A number of SASR soldiers gave evidence. Their identity was protected, and in the case of their evidence in open court, they were heard but not seen. There were also a number of sensitive documents and sensitive information that necessitated the court sitting in closed sessions. That was done pursuant to orders I made under the National Security, Criminal and Civil Proceedings Act 2004 Commonwealth, and speaking broadly related to national security concerns. I will publish what I call open court reasons. They are lengthy. There are also closed court reasons to be provided to a limited number of persons in closed court. I can indicate that the closed court reasons are in the order of 50 pages, and they address in some detail aspects of the closed court evidence relevant to the missions to W108, Darwin and Chinatu. There is a fairly short reference to the mission to Faisal. There are very short references to the alleged bullying of person 1, the alleged unlawful assaults on pucks, and the intimidation of witnesses, collusion and contamination of witnesses, concealment of relevant evidence and material, and lies, and the alleged separation of the applicant and Ms. Roberts. I will be asking the parties and the Commonwealth to consider carefully the closed court reasons and advise whether there are aspects of those reasons which may be published on an unrestricted basis as redacted closed court reasons. It is not practical for me to summarise all of the findings and conclusions as set out in the reasons. The following are the major conclusions. 1, the applicant's conduct and actions on the mission to W108, as found, means that the respondents have established the substantial truth of imputations 2, 3, 4, 5, 6 and 9. 2, the applicant's conduct and actions on the mission to Darwin as found means that the respondents have established the substantial truth of imputations 1, 2 and 3. 3, the applicant's conduct and actions on the mission to Chinatu as found means that the respondents have established the substantial truth of imputations 2 and 3. 4, the respondents have not established the particulars of truth with respect to the mission to Sire Chow on the 20th of October 2012. 5, the respondents have not established the particulars of truth with respect to the mission to Faisal on the 5th of November 2012. 6, with respect to the alleged bullying of person 1, the respondents have established the substantial truth of imputation 12. 7, with respect to the alleged unlawful assaults on pucks, and this relates to imputations 10, 11 and 14, the respondents have established the substantial truth of those imputations. 8, with respect to the alleged act of domestic violence and imputations 7 and 8, I am not satisfied that person 17's evidence is sufficiently reliable to form the basis of a finding that the assault occurred and that imputations 7 and 8 are substantially true. However, I consider that the respondents have made out the defence of contextual truth with respect to those imputations. 9, with respect to the alleged threat to Trooper J and imputation 13, I am not satisfied that the evidence is sufficiently clear to support a threat of the type advanced by the respondents and that they have shown the imputation to be substantially true. However, I am satisfied that the respondents have made out a defence of contextual truth with respect to that imputation. In light of my conclusions, each proceeding must be dismissed. At this point, I would ordinarily publish my reasons, but I understand that the Commonwealth has an application to make in that regard.
That's correct, Your Honour. Your Honour, the Commonwealth makes an application pursuant to Section 37AF of the Federal Court of Australia Act on the grounds referred to in Section 37AG, subsection 1, B and C, for the Commonwealth to have access to the judgment until 2 o'clock on Monday. This would not restrict access to authorised persons, Your Honour, but would seek that the publication of Your Honour's reasons be delayed until 2 o'clock on Monday or sometime earlier, as notified to the court.
Yes, and that's for the purpose of?
Ensuring that there's been no inadvertent disclosure of sensitive information, Your Honour.
Yes, all right. And the applicant's attitude?
That is consented to, Your Honour.
Thank you, Mr Moses.
With respect, Your Honour, we do not consent to that application. Can I very quickly advance the reasons why? As Your Honour, of course, is well aware, there was a very clear delineation between open and closed exhibits, transcript and submissions, both written and oral. Your Honour is, say with respect, of course, acutely sensitive to the need to maintain that separation. Your Honour has written closed court reasons, which, as Your Honour has, may we infer, perhaps being cautious in producing in a way that might in fact overprotect the sensitive information. In light, we would submit of the very clear delineation between what is sensitive and what is not sensitive. We say there is really a negligible risk that Your Honour would have made the inadvertent error of the kind that the Commonwealth is concerned about. And then perhaps more importantly, coupling that negligible risk with the fact that there now exists a necessarily highly truncated summary of what Your Honour has found, we would say it's in the interest of the parties and the public and justice more generally that the full reasoning underpinning those necessarily very high-level findings be made available. Now, there is a fallback position, if Your Honour were not persuaded of that, which is that with all of the resources of the Commonwealth, 2 p.m. Monday is too long a time. there is no reason we would say why, with a sufficiently large number of people, the judgment couldn't be divided up and a decision be made by, we would say, by this evening. Court, please.
Thank you, Mr. Owens. What do you say about that?
Your Honour, in relation to the last issue, there are not that many people in the Commonwealth who are aware of the sensitive information who would be able to identify if there has been inadvertent disclosure. In terms of public access, with Your Honour's reasons, Your Honour's orders have been articulated. We're just seeking a short period just to ensure that there has been no inadvertent disclosure. We appreciate Your Honour will have taken all steps necessary to try and ensure that it hasn't happened. But in these situations where Your Honour and the parties were constantly moving between open and closed courts, there is always a risk of inadvertent disclosure, which once it's released into the public domain can't be undone, Your Honour.
Yes, thank you. Yes, well, Mr. Owens, I'm against you. I do propose to give the Commonwealth the opportunity to carry out that process. So I'll make the orders that have been sought, and I'll read these orders in a moment.
Thank you, Your Honour.
Yes.
Your Honour, I have a copy of short minutes of order to them.
Yes. Now, Ms. Single, there are some open court and closed court reasons for my ruling in relation to 3 witnesses, I think persons 4, 66 and 56, in not requiring them to give evidence under section 128(4) of the Act. It may be convenient for those to be included in the order as well. In other words, you'd be given the open court reasons, and you could do that checking process.
Certainly, Your Honour, we'll do that in the same time frame.
All right, and I would ask that you complete the task as quickly as you're reasonably able to.
Yes, Your Honour, and if the task is completed beforehand, we'll let Your Honour's associate know.
Yes. All right, well, in relation to that matter, I'll make the following orders. Pursuant to section 37AF of the Federal Court of Australia Act 1976 Commonwealth, the Act, and on the grounds referred to in section 37AG 1B and C of the Act, there is to be no disclosure by publication or otherwise of the open court reasons for judgment in Robert Smith v Fairfax Media Publications, Proprietary Limited, number 41, 2023 FCA 555, and Robert Smith v Fairfax Media Publications Proprietary Limited, number 40, 2022 FCA 1614, defined as open court reasons, until either the Commonwealth notifies the court and the parties that it has no objection to publication of the open court reasons, or 2 p.m. on Monday the 5th of June 2023, whichever is the earlier. 2, Order 1 does not prevent disclosures of the open court reasons to and between authorised persons within the meaning of the orders made on the 15th of July 2020, as most recently amended on the 19th of May 2022, under sections 19(3)A and section 38B of the National Security Information Criminal and Civil Proceedings Act 2004 Commonwealth. Now, I think it's a matter of both sets of reasons being handed to the parties and the Commonwealth, and then those orders will now take effect.
Your Honour, there was just one issue that I wanted to raise, if convenient, whether Your Honour would be willing to extend the time within which to bring an appeal from the usual 21 days to 42 days.
Yes. Well, Mr. Moses, I'll deal with that. And
Please, the Court.
yes. Mara and the other ones as well. Yeah. All right. Well, I'll make an order in each of the 3 proceedings that the proceeding be dismissed. Mr. Owens?
In relation to costs, Your Honour, would Your Honour give us 21 days to consider any application for both a special order as to costs in relation to the applicant and any third-party costs order that we may wish to seek? You put it this way, Your Honour would certainly, we would say, if Your Honour could make pro tem an ordinary cost order in our favour, that would follow inevitably, but I think we indicated in our written submissions we do anticipate making an application for indemnity costs, at least against the applicant, and also a third-party costs order, possibly on an indemnity basis as well.
Yes. All right. And then what would happen at the end of the 21 days, Mr. Holmes?
We will have filed an application with any supporting evidence. And then I suppose it depends whether Your Honour could program now a response by any affected parties, or the matter could be called for directions.
Yes. Well, the amount of time that the applicants might need to respond, and possibly any third party, might depend on precisely what orders you seek. So I think it would be wise to have a case management hearing or a directions hearing, perhaps 28 days after today. Mr. Moses, do you want to be heard on that?
There's no opposition to that, Your Honour.
All right, thank you. All right, well, I'll yes, I'll list a directions hearing for 9 o'clock on Thursday, the 29th of June, 2023. Now, Mr. Owens, you heard Mr. Moses say seeking an extension of time.
I don't oppose it, Your Honour.
Yes. All right.
Actually, from 28 days to 42 days, Your Honour. I think it may have said inadvertently 21 days.
All right. And I'll make an order extending the time within which to appeal from 28 days to 42 days.
Please, the Court.
Yes. All right. Well, I will shortly move into closed court to publish my closed court reasons. As I have said, I will ask the parties in the Commonwealth to consider carefully whether there are aspects of the closed court reasons which might be published on an unrestricted basis. And I don't think there's going to be any need to come back into closed court.
Not for our part, Your Honour.
No. All right. Well, we'll adjourn into closed court.
We'll stand. This court is now adjourned.